Next, it's Sarah Boone's big day out as her latest enlisted lawyer argues for a months-long delay to design a defense. Will Judge Cranick entertain the notion, or will Boone's brief buy the farm? We'll tell you straight ahead. I'm Tiffy Lou, and this is Absolutely Criminal. Just having been seated and looking like she swallowed the canary, Sarah nods her noggin confidently in the direction of number 9. That's what we're calling her latest attorney, Wanted Wielder James Owens. She then locks eyes with us in a guileful glance that says, "I've got 50 things planned, but I'm only gonna need one, bitches." After her lucky new attorney checks in, the Perpetual pretrial detainee is sworn in on September 3rd. The judge then explains that today is the deadline for viewing the electronic and physical evidence in open court. You see, Sarah was presented with the digital discovery in her case a few weeks earlier on August 9th and viewed additional evidence at the jail on August 30th. We get our first good look at the new kid on the block as he discusses some other housekeeping matters with the judge. Is Mr. Owens simply a short-term seat warmer? Or will he be Sarah's forever lawyer? Next, Sarah's 9th nominee explains that he was never given certain important items. The state's attorney begs to differ.
We cannot find the autopsy photographs, which he says are critical. Cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the stats of the provision of the autopsy photographs and the crime scene photographs and provide for counsel?
We provided all of those things previously, obviously, to the defendant. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovered to be emailed to him, just so that he could quickly have that and not have to worry about did it got from his client or whatever. He just needs to provide USB, and we can go ahead and burn that for him. He wants to come back to my office, we can do it this morning/this afternoon.
You sure is this in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
I don't have a USB with me, but I'll find one this morning. We'll get that.
Okay, I appreciate you, but
No word yet on whether Mr. Owens has located the state attorney's office or a USB drive, but we do know he did stumble upon this flyer Sarah suggested should be placed in the court's break room. Not only did the crude recruitment earn a response, but the responder admitted he replied to it. And this very real motion submitted to an actual court of law. It was an interesting choice. Back in the courtroom, Sarah's newest hopeful attempts to make the case for a new expert in the case.
You know, I want to make sure that there's not an issue about my client Sarah Boone manufacturing a defense. And there is a second doctor, Dr. Michael Braden. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laid on the couch. And
Interesting that Owens invokes a very specific instance where a woman fired 9 times when Sarah, well, you get the idea. With the clerks so far looking more judgy than the judge, Owens finally gets around to the meat of his motion. Did Sarah feel an immediate threat from George?
But Dr. Brandon testifies that battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
As Owens awaits his response, we'll pause a few seconds to humbly implore you to hit thumbs up below this video, which is conveniently located near the subscribe button. Please push it and ring the bell if you want us to inform you when Sarah writes a letter about today's outing. Now, let's continue with the motion to continue as the defense continues. Will Judge Cranick agree with Sarah that another procrastination is appropriate? The gentleman you see going to town on the Trident is Investigator Billy Lane. The defense hired the private dick to deconstruct Sarah's long and turbulent history with George.
He's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Miss Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered-style syndrome. That we have cooperation. It's going to take a little bit, but I do need the appointment of that expert.
And now, the moment you've been waiting for and totally not fast-forwarding to. It's time to dissect the defense's motion of continuance, which could, literally and profusely, add months to the over 4-year affair.
That takes us now then to your motion for continuance file that was filed by August 30th. Courts had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered-style syndrome. And as you know, that takes time to develop.
An unenthusiastic expression adorns the face of the defendant as Owens continues to argue.
Especially with the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered-style syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. It's just going to take some time.
As experts continue to unfurl the onion, we're reminded that only tears the defendant has shed in 4 years were likely for herself. Sarah's cartoonish persona persists in part because she has never said that she's sorry George is dead. Even while maintaining it was not intentional, she could act like an actual person and express condolences. Throughout hours of police interviews, numerous court appearances, and more fucking letters from jail than we can count, she has never, not once, said sorry to George's family. That's why she's indeed as world famous as she believes herself to be. George Torres Jr. was not a perfect man, but he did not earn or deserve the horrific fate he suffered as he suffocated and called out the name of his supposed lover. And the only person who could unlock his coffin and save his life stumbled up the stairs and didn't come down for a dozen more hours. We want this trial to get underway. Yes, for the spectacle of Sarah's ridiculousness, but so George's family can finally have whatever ounce of closure is still possible in this case. So they can look Sarah in the face at her sentencing and tell her what their brother, their son, their father meant to them. May George rest in peace and finally see the justice he deserves. We will let the remainder of the hearing play out without commentary as Judge Cranick renders his decision.
Mr. Owens, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case. I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions. You just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that would not continue for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list, disclosing Ms. Dr. Harper as a testifying expert. And as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Jorge, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Jorge specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JACS is not here to have the opportunity to review those. In Roberts versus State, 75 Southern 3rd 1277 at pinpoint 1281 by the 4th DCA 2011, citing to Lawson v. State, 884 Southern 2nd 540, also by the 4th DCA in 2004. In that case, defendant Palmos changed his defense counsel at least 4 times while this case was pending, with the latest change to counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation plan for trial, the set forth in the court's June 28th order. The case has already been continued 16 times. As of the date of your filing your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing of this matter. Considering the prejudice of this denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out Padilla, Backwoods, Hobson, and Cashman, and only has herself to blame for the withdrawal of those attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, is established by counsel's representations at various hearings, the prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court-appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all factors as set forth in Timothy State 311 sub 3rd 185 at pinpoint 189 for 2nd BC at 2020, your motion for continuance is denied. Matter of this trial is still set for October 7th.
Sarah, see you in court.